What's up, everybody? It's Jason Cruz here once again with another episode of The Legal Submission. And before we start this episode, I will tell you once again to like, subscribe, follow MMA Payout, go to MMA Payout's website at MMAPayout.com, follow the YouTube channel, get all the information on combat sports and the legal happenings behind it. Now, we had done a video on the UFC antitrust lawsuit in which we detailed the plaintiffs obtaining class certification for the ballot class. And now we get into a little more of the details of what's going on. So a actual status conference took place this past week with respect to what's going on with the rest of the case since the class certification went down. Obviously, the Ninth Circuit Court of Appeals will take the appeal, and although some people indicate that the timeline for the appeal is very short, it actually is very long. So the appeal hasn't been filed yet. It's 14 days from the issuance of the order, which was August 9th. So in the next couple of days, Zuffa will file its appeal. At that point, we will hear the Court of Appeals will be notified of the actual appeal, and then from there the process begins. And there is briefing schedules or arguments, things of that nature. And don't expect it to be done by Christmas. Don't expect it to be done by this spring. It's going to happen next fall. Now, the case cannot go on until that's resolved. Because if the appellate court overturns Judge Boulware's decision, then the order will come back for Judge Boulware to have deny class cert, first of all. And then that would mean the plaintiffs would have to file individually. So you can't go through a case and then go back and have the case do-over because the individual you can't have a class cert. So to answer people's questions, you cannot have the case go forward if there's an appeal. You can't. Sorry. Now, what had happened on the status conference? A couple things, but the main thing is that plaintiffs, and I believe that Judge Boulware sided with them, want to fast track this case. Obviously, it's been on the shelf for a long time. It's been around for almost 10 years without getting a trial date until, of course, Judge Boulware sent that order on August 9th. So what happens is that they wanted to fast track the case. No more discovery. Probably you'll be able to renew the motion for summary judgment, but they want to do it the spring of 2024. Now that's great. Will it happen? I'm, in my humble opinion, say no. Fast track is not going to happen if there's an appeal occurring at the same time. In fact, the court can't do anything once the appeal goes forward, in my opinion. Now, there was another issue involved here in which the plaintiffs, as now the class certification council, wants to have the Sparacino firm wants us to basically cease and desist from soliciting any potential class members. From the inference you can take from the pleadings, it would appear as the Sparacino law firm, which also is a class action law firm, they have fighters that they want to be represented, they are representing in the lawsuit. Now, if you go back a little bit, you recall that the plaintiffs' attorneys for Zuffa, plaintiffs' attorneys for Kung Lee and the fighters, they were offended that the Sparacino law firm was soliciting potential class members, and they wanted them to cease and desist, or they wanted them to stop. They wanted a court order. They wanted something for them to back off of their potential clients. And the Sparacino law firm filed papers to the court, Judge Bulwer's court, indicating that they didn't do anything wrong. They did sign up fighters, but that was under the own will of the fighters. They didn't misrepresent anything, and now they come and say that if the plaintiffs' lawyers want a hearing or some sort of order from the court telling them to stop soliciting class members, then they want full discovery. And in fact, they claim that the plaintiff's attorneys attempted to extort or do under unsavory means to stop the Sparacino law firm from obtaining any potential clients. So there's that issue. The obviously there is some push-pull with respect to just to the business of law, right? Firms need clients. Plaintiffs in this lawsuit, plaintiffs in this lawsuit don't want free riders, right? Allegedly free riders. The Sparacino law firm obviously saw an opportunity, and they did what you're supposed to do in the business of law. They tried to solicit people. Now, whether that's right or wrong, it's up to the court. It's up to the ethical rules of lawyers. But that is the issue. Now, the plaintiff's attorneys will try to frame it like the Sparacino law firm tried to usurp or mislead or take away from the plaintiff's attorneys their potential power to solicit these class members. The plaintiffs for the fighters will say that the Sparacino law firm attempts to just swoop in and take away all these clients after they put in so much time and energy in working up this potential case. So is that an issue for the court? Could that be an issue for the court? Can the parties settle it out? It is determined based upon money, right? Both firms will make money off of the fighters. That is how the business of law works. You work for money. This is not a little small claims court action. Both law firms seek an opportunity, and this is what's happening. So there is that issue that's occurring underneath the actual meat of the antitrust lawsuit. Now, Zuffa had also filed some paperwork, which is kind of now moot because they had argued that they had argued that they needed some more time, that the issue of injunctive relief in Judge Bulwer's order was not fleshed out, and in fact, Judge Bulwer said that there is a potential for more hearings regarding the injunctive relief that was claimed by the plaintiffs, right? The injunctive relief is non-monetary relief, but according to Judge Bulwer, was not clear as to what the fighters wanted. So we have that potential issue, and Zuffa is latching onto that issue and saying, hey, we need to have some discovery based upon this, right? We need to have some discovery based on what they actually want. Obviously, the underlying issue is that, hey, they are just trying to string along this case as long as they possibly can to expend as much money out of the plaintiffs as they can because they can. It's Zuffa. They're making be dealt with. They're planning to extend this litigation as long as they can. That's a strategy by the Zuffa attorneys. It's plain as day. And obviously, the plaintiffs' attorneys want to get this to trial as fast as it can. Now, the advantage of trying to get this fast tracked and pressing for a trial date is because it puts pressure on the UFC, obviously, because they essentially don't want to get this to trial. They don't want to. They don't want to get it to trial. They want the appeal to go through and see if the appellate court will overturn Judge Boulware's decision. If it gets to trial, it's a crapshoot as far as who wins, who loses, and at that point, you could see mediation or kind of a settlement conference or something of that matter. Now, what happens with the Sparacino law firm if the court allows them to continue to represent the fighters it does represent? Now, we don't have any names on who is represented by that law firm, but the thing is, as class members, the fighters in that bout class defined by the lawsuit can decide whether the plaintiffs currently representing Kung Lee and the other fighters, if they want to be represented by them, the Sparacino parties that want to be that are represented, and there is an opportunity to opt out altogether and find yourself your own legal counsel, and that with that part, then you'd have to pay for your own lawyers. If you go with the class action lawyers appointed by the court, you could just go ahead and go with them and not pay any attorney's fees up front. In the end, if there's a judgment, verdict, or a settlement, obviously there's a doling out of attorney's fees, costs, things of that nature before the settlement money is given out to a fighter, if any. So there is that case. Now, obviously, one underlining thing again is that the Sparacino law firm and the Berger Montague law firm and all law firms that are involved in this particular litigation will have to work together. And so that is another reason why the plaintiffs currently don't want to have another law firm that they didn't already partner with in this lawsuit, because there's a potential for impasse, disagreements, things of that particular nature. So there is that issue. So what happens next? We had the status conference. We had the issue regarding the appeal. I, in my opinion, believe that once the appeal is notified, we will see that will create this domino effect as far as whether or not the court case is stayed, whether the case goes forward. Who knows? In Judge Boulware's court, maybe the case goes forward. I didn't know, and everybody else knew that this case was going forward despite an appeal. Who knows? We will see. But my opinion here is that the filing of the notice of appeal will trigger multiple effects for this particular litigation. Now, with respect to the Sparacino law firm and the Berger Montague law firm, the plaintiff's attorneys duking it out, I did not hear any issues coming out of that status conference. In fact, I don't think that Sparacino's talked at the status conference. Whether or not the court decides to have an additional hearing on that matter will be an interesting one, because it won't deal with the substance facts again, but it deals with the business of law and how the case might be litigated once it gets to that particular stage. So this is Jason Cruz with the MMA Payouts, the legal submission. Hang out. We'll talk to you later. Bye.